Hi everyone, I'm Jordan. I'm a business support advisor here at the Business Support Service, and today I am joined by Nick, and we're going to be doing a webinar on understanding your intellectual property. Now, Nick is from the Intellectual Property Office, so it's great to do this joint webinar to give you lot a very good understanding. But before we do, I just want to give you a bit of an introduction. If you've never
social media, but not 100% what the business support service do. Who we are.
information guidance service offering a multi-channel service across England. We do have counterparts in Scotland, Wales and Northern Ireland, should you be from there as well. Now, we do form a key element of the government's business support provision, working on behalf of the Department for Business and Trade, DBT. Now, what we do, so we help businesses of all sizes, from the very beginning stages of planting that seed of an idea of a business, all the way up to businesses that are being established and trading, some for generations. Now, our advisors can signpost you to a range of different information and national and local schemes, as well as resources to help your business start as well as grow. And this is a key part of our business. We are there to help take the legwork of research or understanding of what is available to you. And we cover a host of different subjects when you speak to ourselves. We can go over things like business planning, the importance of business planning, legal structures, especially at the very beginning. Should you be a sole trader? Should you be a limited company? Are you considering partnerships? Find localized and national support schemes as well. Signpost you to relevant funding options. Give reliable information and impartial advice so you can make informed decisions. It's very important that you're making decisions based on research so you can make sure you'll make the right one at the right time. And we have in-depth discussions as often as you need on them and give you this information. It is important to note, though, our advisors aren't legally trained nor are tax trained. And any queries relating to those subjects, we will look to signpost you to a relevant resource. Now, we do cover subjects such as intellectual property as well as innovation, the understanding of tax. We just don't go into personal tax details or taxation in general. We'll cover regulations and legislation, employment of staff, including apprenticeships, and international import and export. So if you're looking to explore new markets. And how does it work when you reach out to us? Well, first and foremost, you'll either call the service, email. We've even introduced WhatsApp recently as well. So you can reach out to us on one of those forms and you'll speak to an advisor who will take information set up in a record, a customer record with us. Now, these are what we call our tier one advisor. Our lovely advisors will be able to take this information in order for us to help you. And you need to provide some information as well. Okay, so you need to provide things like your postcode, your location, so we can identify localized support. Some information on yourself, on the business, and sort of what you're looking for if you have an idea as well. And they'll arrange an appointment with one of our tier two business support advisors, someone like myself, who'll have a bit more of an in-depth conversation and understanding of your business. Now, these are one-to-one virtual appointments, and they can either be completed via Microsoft Teams or telephone. And we run these appointments on an hour basis, but that gives us time to write up an action plan in email for you after the call as well. And we'll have a bit of a conversation. We do a diagnostics on the business, so we'll ask questions in relation to where you're at with it, what your plans are moving forward. Have you built stuff? So, for instance, are you looking for finance? We'll look at whether you've got a business plan in place, as an example. And the advisor will provide general information on the support available, signpost you to any specialist advice you require, as well as local and national support. We also offer follow-up calls, so maybe that hour wasn't enough, or you've got something in the future that you have a few questions on. Never be afraid to come back and have a chat with us as well, and you can reach back. I just want to note as well, before I hang over here to Nick from the IPO, I just wanted to let you know that we do have some people within our discussion forum, so you can have it, ask questions below there, and they'll look to answer. But without further ado, here's Nick from the Intellectual Property Office. Thank you.
Thanks, Jordan. Thank you very much. Good morning, all. And yeah, my name's Nicholas Chard, and I'm one of the business outreach officers here at the Intellectual Property Office. So I'm going to talk to you this morning, all things IP, of course, and as Jordan mentioned, there will be a time at the end as well for a bit of a Q&A. Please feel free to put any questions in the chat function as well as we go along. So we at the IPO, we're the official UK government body for granting intellectual property rights within the UK. We cover patents, designs and trademarks, and we also deal with copyright, though there is no register for this, but we do have a copyright department that can deal with queries as well. So what is intellectual property? Well, it's the collective term for the creations of the mind or the fixed formats in which they can be protected. So as I mentioned, we deal with patents, trademarks, registered designs, copyright, unregistered design rights, and also confidentiality and trade secrets. Now, the bottom two are for more so when potentially you have something that doesn't quite maybe fit into the trademark bracket, or it's not quite a patent or registered design, and there may be an opportunity there for confidentiality and trade secrets to help protect what you have as well. So firstly, this morning, we'll talk about trademarks. So trademarks is any sign which is capable of distinguishing the goods or services from one undertaking another. It is the R in the circle that you would put on your trademark that represents that you have a legitimate registered trademark. You may well see from time to time a TM next to a trademark. You are well within your rights to do this. However, this is not an official registered trademark. This is used on occasions as act as a bit of a deterrent. A lot of people think that the TM is actually a registered trademark, but is in fact the actual R in the circle that is a registered trademark. It can be renewed indefinitely. Once registered, you have 10 years before your next renewal. And as I said, it can be renewed as much for as long as you do so wish. And it is exactly as it says there, it's a badge of origin. It's something that you want your customers to recognize as a sign of the quality of the goods that you're providing. So in turn, they become your repeat customers and recognize your logo as that quality. So what can we actually register here at the office? You can register your name, your color theme, logos, shape themes, domain names, actions, slogans, and signs or jingles. Now, names, logos, domain names, slogans, just the list there on the left-hand side, they're the more popular trademarks, shall we say. And then colors, shapes, actions, sign, jingles, a little bit more difficult to prove, but say in which you can still obviously register them as a trademark as well. And the mark must be distinctive for the goods and services you provide. So you can't be too descriptive of the goods that you provide. So if you take, for example, Apple, if you didn't know who they were, what they did, it doesn't describe that they are a tech company. However, if Apple were a greengrocer, if it was a greengrocer, the company, the business was a greengrocer, it would be too descriptive of the goods in which they provide. So it can't be too descriptive there. Just some examples there as well of the registered trademarks that we have. So what can't be registered? So you can't register anything that's offensive, can't be too use lottery terminology or words and shapes in common usage of class and goods in question. So an example, lottery terminology is the best a man can get, of course, belonging to Gillette. So Gillette, as you will see, it has the little R in the circle, but the best a man can get would be classed as lottery terminology, excuse me. Who says it's the best a man can get? So it wouldn't pass the examination. You can't register anything such as be non-distinctive, such as we lead the way, and use protected emblems either within your application. So some slogans as registered trademarks. Let's see if this can work now. In the chat function, see if you can put your answers to what you believe these slogans relate to. So number one, it does exactly what it says on the tin. What do we think that one belongs to? Any answers? Anyone? Okay, that's okay. So, Ron Seal, good things come to those who wait. I'll leave the chat function open just in case anyone wants to answer. So good things come to those who wait. There's Guinness. It's good to talk. Ah, perfect. Yes, apparently. Sorry, apologies, I was looking in the wrong place. So you are answering me. You are alive. Brilliant. I love that. Thank you very much. So yes, Ron Seal, we've got Guinness in there. BT, Nathan, thank you very much. Becky also went with BT. Yeah, fantastic. Brilliant. There's me thinking you didn't want to talk to me as well. Amazing. Thank you all. How do you eat yours? Cabbage cream egg. Yes, indeed. Thank you very much, Nathan. It is indeed. Buy it, sell it, love it. eBay. Yeah, thank you, Becky. Vorsprung Dutch technique. Come on, Farrell, you're all right. You get them. Yes, Heidi. There we go. There we go. Why have cotton when you can have silk? Think chocolate. Galaxy Amanda, well done. Yes, Nathan, well done. Jumped in with the Galaxy as well. Yes, indeed. The world's local bank. Yes, Charlie, thank you for Galaxy there. The world's local bank. HSBC. Yes. Believe in yourself, Nathan. Don't put a question mark there. We were right. HSBC, thank you as well, Becky. Once you pop, you can't stop. Never truer words spoken. Pringles, absolutely. Yes, you're all flying in with that, Amanda, Charlie, Nathan, thank you very much. And finally, impossible is nothing. This is one that usually stumps people, but let's see. Think sports brands. Oh, it's not Nike, Farrell, sorry, excuse me. 2 out of 10. Adidas, yes, Jessica, thank you very much. You got it. Indeed, yeah. And more so, obviously, it was nice to have the interaction, but it's show you as well the power of a slogan, what it can mean to a business as well. And obviously, you were all jumping in. A number of you were jumping in there with the answers, so they resonate. So when it comes to the costs in the UK, it's £205 for the application fee, and that includes one class. Now, there are 45 different classes of goods and classes to choose from, and they range everything from food and drink to clothing to engineering to science. You choose the trademark, the class which best suits where you're going to use your trademark, I should say. And then for every additional class on top of that, then it's £60. If you are thinking that you want to go a little bit further afield with your trademark, you can go to the EU IPO, which is the European Intellectual Property Office. And that's €850, and that includes one class as well. Now, a little bit more expensive, as you can see, but that does cover off all European member states within that application. And then if you're going further outside of Europe again, you can go to WIPO, which is the World Intellectual Property Office. Use something on there called the Madrid Protocol. And the fee calculator is available, and it just depends on how many countries you choose as to what your final fee will be for that. This is something certainly in the UK that you can do yourself, straightforward application. And we at the office, we have a customer support centre who would be more than happy to help you through elements of your application. So something you can do yourself. But if you feel like you maybe need that little bit of professional legal advice, especially if you're going abroad with your trademark, CITMA, which are Chartered Institute of Trademark Attorneys, are a great organisation to be able to point you in the right direction of potentially an attorney in your area to help you. So we do have a search on our website regarding trademarks. Now, searching before you register your trademark reasons to do so. You will avoid those expensive mistakes, become aware of competing marks, and early resolution of potential problems if anything does arise. And it's absolutely free. You can use the search engine as much as you want, as many times as you want. It's still free. It remains that way. And as I said, it will avoid those expensive mistakes. And the reason I say this, once you've put your application in, you've paid for your application, it's non-refundable, regardless of the outcome, whether it passes or fails the examination. And also knowing you don't want to start branding everything with your trademark and then and spending all the money and then finding out down the line that someone already has the ownership of that trademark. So it's certainly worth checking before you do so. And moving on to copyright. So copyright, as I very briefly mentioned at the beginning, copyright is an automatic right in the UK. There is no register for this. And that being said, it's all about keeping proof that the work is yours and you created it at a certain point. So when the moment you put your work into its fixed format, you have copyright protection. So I put these slides together today for you all, and therefore they immediately have copyright protection. So the idea being then is I keep as much proof as I possibly can that the work is mine and that I created it at a certain point. So document your work, take pictures of your work. Obviously there'll be a date and timestamp on there. You may have even heard of sending your work to yourself in a recorded envelope and keeping it sealed. Again, that can add as proof that it is your work as well. So what copyright protects is literary, dramatic, musical, artistic works, and they cover off books, music, photographs, paintings, manuals, dance or mime, and also protects sound recordings, film databases, and broadcasts as well. What it doesn't protect, though, is when works are in the public domain. So copyright does have a timeline, which I'll touch on shortly. But once it does come out of that timeline, it's then in the public domain and cannot be recopyrighted. So it would have expired. The copyright would have expired, so to speak. There. Ideas. So copyright protects the expression of an idea, not the idea itself. You cannot copyright single words, titles, or facts either. And perfectly, how long does copyright last? So published editions is 25 years, TV and radio broadcasts is 50 years, sound recordings is 70 years, and literary works, films, music, dramatic and artistic is the lifetime of the creator plus 70 years. There is one unique ruling to that, and that is around Peter Pan. The ruling, it was passed in court of law that Peter Pan will never come out of copyright timeline, so it will forever stay in there, and all royalties, copyright royalties around Peter Pan, so the movies, the books, the memorabilia, will always go to Great Ormond Street Hospital, the Children's Hospital, which I think we could all agree is one unique law that we're more than happy to be passed. But for us mere mortals, this is the timeline that we see on the screen. This is the timeline we adhere to when it comes to copyright. So who first owns the copyright? Well, it is usually the first creator or author. So an employer will usually own the work if it was produced in the ordinary course of employment. So as I mentioned, I created these slides today. However, it is in the ordinary course of my employment. So therefore, as it goes, it's the Crown that owns the copyright to this, as I am a civil servant, of course. A contractor may retain ownership of works created, although this can depend on their contract. So, for example, let's say I want a web page designed. I want a web page created, I should say. I give the designer everything, how I want it to look, all the colors, everything about it. I pay them for their work, unless there is a contract in place that states once this work is completed, the IP automatically transfers back to me. They will own the copyright to that web page. So as you'd imagine, 99% of web designers would be happy to sign such a contract, as they're looking for the paid work, not as much as to keep your IP. However, if that contract is not there, they will own the IP to that web page. And moral rights are still retained even if the creator sells their copyright. So you can sell it and it no longer belongs to you, but if it's being used in the future then in a manner in which you don't agree with or that you don't like, you can still impose your moral rights and stop that from happening. So there are some copyright exceptions and permitted acts. As it says, non-exhaustive list, but it includes private study, education, libraries, research, incidental inclusion, disability, criticism review, news reporting, parody, time shift and broadcast, and some official reports. So just drilling down a little bit into a few of these. Of course, you have education. So if the copyrighted work is being used in an education setting, of course, no profit being made from it, then you're well within your rights to do so. Incidental inclusion, if you are, excuse me, taking, let's say, a picture of a friend, your friend is stood in front of a building that, let's say, shouldn't be photographed, but the picture is of your friend, then the building would be incidentally included in the background. Disability, so if, let's say, some copyrighted work is changed to Braille for someone who's partially sighted, and that falls under the exception as well. And parody there. So every year, dare I mention it all the way in April, but every year at Christmas, I think it's John Lewis who brings out a lovely Christmas advert. And then I think in no time at all, what seems no time at all, I think it's Lidl's or Aldi's bring out their parody of that advert as well, but well within their rights to do so. Okay. So another bit of interaction. So this one here is it's not as morbid as it may seem as well. So copyright, of course, can bring in a lot of money for you and for your business. So this is the top dead earners slide, and this is what people have earned in the year 2025 alone. Now, this is not since they've been passed. They're from all walks of life, musicians, novelists, artists. Who do we think makes the list? Nathan, straight in with Michael Jackson. Yes, absolutely, he does make the list. We're going to count it down from 10 to 1. However, if you can throw some guesses in the chat, that would be amazing. So Nathan's kicked us off with Michael Jackson. He is certainly he's on this list. Any more? Who else do we might think might be on there? Elvis Presley, Nathan. Yeah, thank you, mate. Absolutely. Elvis Presley is certainly on there. George Michael, Amanda. It's not a bad guess, but he didn't make the top 10. Queen didn't, no. Freddie Mercury, no. Roger Hargreaves, no. Not bad guesses. Oh, Shakespeare, I think, would be out of copyright by this time now, Aaron. But not a bad guess, to be fair. David Bowie, no, he hasn't made the top 10 list, not this year. So number 10, we got, keep the guesses coming though, this is good. Elton John, Charlie, they've got to be dead. Sorry to be, but he's still alive. Number 10 is John Lennon, passed in 1980 and still earned £9 million in 2025. Multitasking, fair enough. I'll forgive you, Charlie, on that one, no problem. Emma said, Alan Watts, no, afraid not. He's not made the list. Who else have we got? Bob Marley. So passed in 1981 and still earned 10 million through his copyright in 2025, excuse me. James Brown, no. Sorry, Charlotte. James Brown doesn't make the top 10 list. I've only got the top 10 list, so some of your guesses may well be further down the list. But certainly, Ozzy Osbourne, no. That's a great shout as well, Amanda, and he's not there. However, there are reasons as to why people will kind of come and go on this list. and I know that Nathan guessed Michael Jackson. He is on the list, and big reasons for him. Obviously, his music is still very popular today. His film being released in 6 days' time. The Cirque du Soleil show that runs in Vegas, I think it's just hit over 1,000 runs of that. So there's going to be reasons as to why. Look, I believe a few years ago, J.R.R. Tolkien made this top 10 list, and that was due to the rights to Lord of the Rings being sold to Amazon. I believe there was a £400 million purchase, and that's why, of course, that one payment put J.R.R. Tolkien on that list. Whitney, no. Amy Winehouse, no. Frank Sinatra, no. These are great guesses, though. These are great. Oh, Biggie or Tupac, Charlotte. That's a great guess. So Jimmy Buffett passed in 2023. 11 million at 8. Elvis Presley, I believe we had Elvis Presley was guessed in there as well. Miles Davis, Notorious B.I.G. There we go, Charlotte. I knew he was in there. That's a great guess as well. Roald Dahl, no. Would Roald Dahl potentially be out of copyright in terms of the timeline? Stephen Hawkins, no. Afraid not on that one. Syd Barrett, Richard Wright, artists as well. 2008, 2006 passing respectively. My absolute favorite, Dr. Seuss, passed in 1991, still in 64 million last year. And top of the pops, Mr. Michael Jackson himself, 79 million. I read actually on Forbes the other day that he has earned, or Michael Jackson's estate has earned 3.9 billion since his passing through his copyright. Huge Pink Floyd fan. I'm ashamed myself. Don't be, Nathan. It's okay. You did throw some guesses in there, to be fair to you. But yeah, again, I appreciate these names a lot of us would recognize, but it's just more so to show again the power of copyright and what it can mean, even after passing. It still obviously can bring in quite a bit of money. There we go, just a few pictures of those people there. Okay, so, and again, thank you very much for all the interaction there. I appreciate that. It was cool. So with copyright, record your work, keep proof, use contracts, license opportunities, and there are no official registers. However, there are some unofficial registers that you can register with, such as PRS for music, though registration does not prove ownership, only that the work existed at the point it was uploaded. So yes, I'm certainly not saying don't use them, but you need more as well. You need more proof as well. So don't just rely on those. So registered designs. So a registered design protects the overall visual appearance of the product. So not how it's made, not what it's made from, just how it physically looks, so its physical shape, its configuration, the decoration, such as the pattern on the fabric as well. What it doesn't protect, though, as I mentioned, what the product functions, how it functions, what material it's made from, how it's manufactured, and a form dictated by its function where there is no design freedom. So a key, take a key, for example, there, a key has to look the way it does because that's how it performs its function, or even a spanner, it has to look the way it looks because that's how it performs its function. So there would be no design freedom over such items as that. So with the designed costs in the UK here, so we still accept a paper application, but it is cheaper to submit an online application. So for online, it's £60 for one design, and then £75 for the first, and £50 for each additional design in the same application. So £85 for up to 10 designs in the same application. So as long as they don't have to be linked or a series of any kind, as long as those 10 designs go into the same application, then it would only cost you £85 there. So when it comes to the application itself, what you do have to make sure of is about the illustrations. So they should Show design as it appears to the eye. Show design against plain background, so don't have anything kind of distorting the image. Not contain measurements or technical information. We don't need any of that. Not include anything that isn't part of the design. So as you can see on the bottom in the middle there's the mug. We don't want any of that. It must be the same type. So if you submit line drawings, or let's say however many, up to 12 line drawings, they all have to be line drawings. You can't submit some line drawings or some photos. You have to have one or the other there. And it must include the complete pattern and enough to show pattern repeats if indeed it is that is the case if you're registering for a service pattern. So make sure we get to see it in its full there. And patents. So patents protect new inventions, how a product works, and its technical function. So with patents, it is, even though you would be applying here at the UK IPO for UK protection, the search for the patent is worldwide. Now, part of the criteria for a patent is that it has to be new and novel. It cannot be known anywhere in the world prior to the application coming in. Otherwise, this will invalidate your application. It could be, as I said, it must be an invention, but it could be an inventive step on an invention that currently exists. So, for example, take the Hoover, for example. The Hoover's been around for many, many years. And then Dyson, for example, came in and they created the bagless Hoover. So there was a step on an invention that already existed there. And it must have a technical effect as well. So again, we do accept the paper applications. But again, online is cheaper, so £75 online for the application fee. Search fee then is £200 and the examination fee is £130. So in total, we're talking 400. Are we 330? Yes, £405 in total for the application in its entirety with the IPO. One thing I would say around that though is guidance is that you would seek a patent attorney to help you with your application based on just how technical and how complicated it can get with the application. Of course, appreciating at that point, it does add a considerable cost to bring in an attorney, but it is something that we believe is extremely beneficial. Obviously they know exactly all about the applications. And I think it's something as small as 2% of applicants who don't use an attorney actually get them through themselves. So not to say it's not allowed, absolutely fine. It's just guidance when it comes to those applications. So in terms of the process, so with, I didn't mention, but with trademarks, it's 3 to 4 months from start to finish before you get your trademark registered. However, with patents, it's a considerable amount longer. Appreciating, of course, it's brand new, never been seen in the world before. The search itself is global search, so it's got to be a real deep dive for the search there. So just a bit of a timeline of how it all works. So you'll file the patent application, pay the application fee. We will issue a filing receipt, issue preliminary examination report. As you can see then, it moves on all the way. Amendment in response to examination, potential re-examination, and then 1 to 4 years down the line, patent is either granted and republished or refused. The patent lasts for 20 years. So you have a monopoly over that patent for 20 years, meaning if anyone wants to come anywhere near it, use it, license it, whatever they want to do, they have to come through you for that for 20 years. And the renewals are from year 5 to year 20. So with patents, keep your inventions confidential. Use non-disclosure and confidentiality agreements. So in the meantime, as I said, the timeline is obviously considerable amount of time. If you are looking, of course, to potentially use your patent, use your invention before that it gets granted, I would suggest non-disclosure agreements, confidentiality agreements. Make sure no one can discuss your idea or take your idea without your say-so, and make sure that it all stays watertight there. Search for existing and similar inventions. We have a search engine on our website that allows you to do this as many times as you want for free. Make sure it doesn't already exist before you start paying money for your application. And as I mentioned, seek help from a patent attorney to draft your application. Not a rule, more guidance there. And IP abroad. So certainly if you are thinking about going abroad, key message is really, I would say, know before you go, as IP rules and regimes around the world vary significantly. The rules and the laws that we have in the UK will not be the same as other countries around the world. So certainly know before you go. IP is territorial, so IP rights granted in one jurisdiction usually only provide cover within that same jurisdiction. You get UK protection, it's just the UK you are protected in. So technically speaking, if someone in Spain wanted to have exactly the same trademark and use it in Spain, they're well within their rights to do so. Now, they couldn't come into the UK, they couldn't trade into the UK without trademark because that would be infringing yours. But equally, you couldn't be trading into Spain with your trademark, as that would infringe theirs. So it is territorial. So you do need to, I guess, consider where you are going to be making sales or using your trademark as to where you may want to potentially protect it. And it is a first to file system across the world, so act early or miss out. So we do have some resources, International IP Service on gov.uk. I can share these slides at the end with the organisers. I'm happy for them to be shared more wider, so you can actually go into these links. That's not a problem at all. So guidance on how to protect trademarks, patents, copyright designs abroad. We do have country guides. They're really, really good set of guides. Each, for specific countries where there's kind of the do's and don'ts, the routes to take, routes not to take, things to do, things not to do. And we are producing more and more countries as time goes on as well. It's a really good source of information. And we also have IP attaches for one-to-one guidance. Again, there's the link for them, but they are freely contactable. They are spaced out all across the globe. So we have them in Europe, in Asia, in Australia, and they are in essence boots on the ground. And again, they know the kind of do's and don'ts and the routes to take, routes not to take, and a really useful source of information as well. And also the DIT export services too. And so just to close it up there, we have our further support. I know I mentioned the customer support center, the info center there. There's the telephone number and email address. We do have our IPO online toolkits. It's an easy sign up, one-time sign up, and then you have access to all the toolkits going forward. IP for business events. So for myself and the team are out on the road and we're attending events, you can check our calendar and see where we are. Potentially we'll be going if you wanted to come along and have a chat. And then of course we have information on EU IPO, WIPO, who are our of course European offices and World Intellectual Property offices as well. And that brings me to a close on that.
Perfect. Thanks for that, Nick. Now, a lot of really good advice there I'm taking into account. I was terrible at those quizzes, though. I was horrendous. Nonetheless, though, we've got about 20 minutes. If anyone has any questions, feel free to ask them in the discussion forum where you were answering those quizzes that Nick put on there, and we'll try and answer them now. Alternatively, you do have the contact details as well. Ours is on screen there, as you can see. But of course, as Nick said as well, we will share the video to everyone that attended and those that couldn't attend today, and of course the slides as well. But yeah, if anyone has any questions, do ask away in that discussion forum. We do have one, Nick. I tell you what, do you want to take that one, mate?
Yeah, no, is that Charlie? I can just see it was typed into the chat there, so let's see. As a startup e-commerce book publisher, selling physical books, operating from the UK and selling advertising in the UK, EU, US, Canada, and Australia. To begin with, that's a great start to begin with. Where would you advise I register first? Just UK or is EU IPO, WIPO also necessary? Okay, so when it comes to the registration of your intellectual property, you need to take into consideration yes, your key markets, but where you believe it would be, of course, most damaging if someone was to or business was to infringe your work. So I'd certainly start with the UK, get your registration in the UK. And the reason I say these things, so let's say my key markets are the UK and the US. So I register in the UK, I register in the US, and someone in Spain copies what I've done. I need to take into consideration then, is it going to affect me? How much is it going to affect me? To obviously go after them and stop that happening. Or do I think, well, actually, it's not really affecting my key market chain there, and I have no intention of entering into Spain anytime soon. So I'm going to leave it because it would cost me more money than potentially it's worth to me. They are personal decisions, of course. They are decisions that yourself, that a business would have to make. But certainly, I would most definitely register in the UK. And I would consider certainly your key markets. So EU, US, Canada, and Australia. I would look into them for sure, certainly as a starter. Hope that's okay. This is good. Questions are flying in. Okay, so I think Gary came up next on my list. Let's see, sorry, apologies, it's jumping around, it is. Okay, so Gary have said, I'm in the process of building a website and app that will be live on the store over a year. Assuming this all needs on the store over a year, assuming this all needs done before I submit the project, before it goes to the store. So sorry, Gary, are you asking there, should you be registering your IP before this happens? Is that the question? I'm in the process of building a website and an app that will be live on the store over a year, assuming this all needs done before I submit the project, before it goes to the store. I'm interpreting that as, are you asking it, does it need to, should you protect? If I have interpreted that correctly, then I would strongly consider protecting my IP before I did these things. The reality of that one is we all start small. We all start from somewhere, and we want that intention of growing. And when you're small, or when you've started out as small, you might think, oh well, no one knows who I am. The moment you start to grow and become more in the public facing, and people, oh yeah, that's Gary's company, fantastic. Yeah, I'm definitely using that one. Fantastic goods. People are more inclined to then copy, because they'll want to piggyback off your success. So that being said, I would certainly consider before I do these things. If I haven't interpreted that right, Gary, please do type again. Apologies, and I will readdress that. Pharrell, there's lots of questions in the Q&A button. Okay. Also, Gary, if I don't own any products or make them other than the service and the functions of the app, what would I get covered? So you could, do you have a name for the app? Is there a name that you could potentially brand, your branding would be a trademark? The functions of the app, or the app itself, you would have copyright protection over. And again, as I've mentioned, is keeping the proof that it is your work and you created it at a certain point in terms of the copyright. But if there is nothing else that you own or make, then I would be looking at trademarks and copyright for those. Rebecca, we create 2D engineering drawings for enclosures. We design and then provide these to subcontractors who recreate in 3D for, apologies everybody, I'm moving the screen and it's jumping and I'm not finishing the question. Okay, so who creates in 3D for manufacturers' purposes? They then manufacture. How do I ensure we maintain ownership of our work? So to maintain ownership of that work, it needs to be a contract between you and the subcontractors to make sure that whatever they're doing, or however the relationship is between you, is that you still maintain ownership of that. As the creator, in its first instance, you are absolutely the owner of that intellectual property, and regardless, even if you sold sold the design, that doesn't mean you don't own the IP to that design. So you may well create something, that design it, and then give it to the subcontractors, or sell it to the subcontractors. That doesn't mean you don't own that IP anymore. So it certainly needs to be in a contract there. Aaron, thank you for this information. You're very welcome. Jumped debate. Your question is more on copyright. Is there a contact I might be able to reach out to? I would like to understand copyright a bit more before I start posting. I'm happy to share my email address, Aaron, if you have any questions around copyright that you want answered before you start posting. In fact, let me do that here. So I'm sharing the business engagement. It's called the business engagement email address. However, there's only 3 of us in this team, so it will not disappear into the ether and never to be seen again or dealt with by robots. There are 3 of us. So if you put for the attention of Nick, and by all means, I will pick that up and cover off anything. And that goes for the future as well. Everyone, you know, if there's things that you have down the line and you think, I'd really like to know the answer, please do drop an email in. I'd be more than happy to answer those for you. Okay, so Charlie. Okay, follow up to previous question. Cool. I think I'll register in the UK first, then white both for the US, etc. What would you say would be most useful to register first? A text mark? Oh, with that, Charlie, I couldn't answer. That would be a personal decision to be made there. I can't. It would be what means most to you. I appreciate on a budget as well, and especially as a startup, that's always going to be you know, things running around in your head regarding a budget. But it's what is most important to you, I would consider when it comes to registering that trademark. Dave, if my web designer registered the URL and I pay an annual fee to them to maintain the site and keep it registered, do I have the rights on that website? So if my web designer registered the URL, so when you say they registered, have they protected it? Do they have are they the creators of that? And then you, or did you create it? Sorry, Dave, can I just get a bit of clarification on that? I think that's it. But Dave, I'll hang fire for you to give clarification. I think I've reached but I don't think I've missed anyone. Oh, okay. I put the company together and I wrote the content. So you are the creator. So yes, you will own the intellectual property there. Then you are the creator. Again, as I said, you can sell things, but as the creator, you unless there's a contract that states they are buying the intellectual property, then you will remain the owner of the IP.
I know, Nick, there's some questions just over in the live Q&A. Can you see next to the discussion forum, the button there, mate?
Lovely.
I think the more target to you, I had to look through to see Arkadang singing them, but you're quite specialist.
No worries. Yeah, that's okay. I was wondering how patent and trademark protection works across different countries. So, for example, if a product is protected by US patent, would it still be possible for someone in the UK to manufacture a similar product without infringing the patent? Oh, Sam, we're in dodgy territory there. If someone has the patent now, granted, you make a good point. If they only have US protection, then yes, you hit the nail on the head. It's just they would only be protected in the US. However, there is the risk that they will be looking for UK protection. And added, and then if someone is producing or manufacturing that similar product, and again, it would seem how similar that product is. Is it a direct copy and you've just made some adjustments? And that would be, I guess, more for attorney to look at, but certainly it would be a worry for me if the US company started or looked to protect in the UK. That would certainly be my concern there. Pharrell? Okay. Are there other countries that are faster for patent, especially if the UK patents do a worldwide search, e.g. if US patent process takes less time than UK but will still apply here? If you want a UK patent, it will come to the UK IPO. So and if I'm honest, we are actually one of the faster offices. I think Brazil, is it? It's 8 to 10 years. We are actually one of the faster offices. So yeah. By all means, do research. I'm not sure of exact timelines either from international offices. You can certainly look that up, but we are. I am aware that we are one of the faster offices at getting it through. What is needed to submit a patent, given the length of timeline, especially with the timeline to commercialize a new solution, saying it'd be much shorter? Sorry, I'm trying to get to the bottom of your question, Pharrell, and it's not letting me. Oh, perfect. I got touchscreen. Does the application apply worldwide? Hold on. Okay, what is needed to submit a patent given the length of the timeline, especially with a timeline to commercialize a new solution sound like they will be much shorter? Also, what needs to be included in the patent application? Is that the reason you say include a patent lawyer because the requirements for submission are complex? Yeah, it certainly is complex procedure. So what I want you to think of when it comes to a patent is the fact that it's never been seen in the world before. No one knows. So I'll say, if my example always is, take a chair, for example. You've never seen it. You have no idea what it is. Explain it to me. You have to explain every little bit, and there's going to be claims. There's going to be abstract about all within the application, which is kind of where the patent attorney certainly earns their pennies for. So you just need the invention in terms of when you've said what is needed to submit a patent given the length of timeline. You need to submit the invention, the application, and again, our customer support center can assist you with that as well if needed. Does the application apply worldwide in that case, or would you need a patent in the US? No. So you apply in the UK, only protects the UK. If you want protection in the US, then it would be the US you apply to. What does in the public domain mean in practice? Example, if I present my copyrighted framework at a conference, does that count as public? Yes, yeah. So public domain out there in the public is it known out in the public domain? So is it being shown? Is it on social media? Is it at exhibitions? Is it being shown? Is it out in the public domain? It is when you've got to be mindful that it's out there. What is the main difference between using EU IPO versus including EU as part of a WIPO application? You can go directly to WIPO and cover off the EU countries, if you like, within that application. There's certainly no ruling or reason to go to either one. Obviously, EU IPO directly deals with the European member states, and WIPO is worldwide. So that would be personal choice. What should a startup do where trademarking might be cost prohibitive? What would the consequence of not protecting your trademark? Potential of somebody copying, but I totally appreciating that cost is a factor. It's potential of somebody copying and running with your trademark. I mean, look, if indeed it is just an absolute no-go, then potentially look to build the business. And when you do, you think you can spare those funds, then I would still look to trademark and protect, because again, as I said, the bigger you get, the more the public eyes are on it, and potential of someone piggybacking. But yeah, Okay. Have I missed any now? I think I've covered them.
I think there's just one from Dave, Nick, there, came in about a minute ago or two. I think that will make that the last one as well, buddy.
Sorry.
Live Q&A
we
part.
in the live Q&A.
Yeah. I don't know if you can see that on my screen.
Oh, I got it. Okay, I've received letters from companies saying they have someone wanting to register a company in my name and also offering to register it for free for me. Am I best? Yes. Ignore them. These are people looking to, from what I'm reading there, are looking to get your money and charge you a little bit over exactly what you should be paying. So I would, certainly guidance would be to come direct to the UK IPO.
Amazing. Thanks, Nick. I appreciate taking all them questions there. They were
no worries.
Were very good questions, weren't they, from everyone?
They were, to be fair, yeah. No, I appreciate that. It's always good to get the questions in and get them out there, absolutely. So thank you very much to everyone for the interaction throughout the whole presentation as well. Thank you.
Oh, it was a fantastic presentation, and thank you for coming along and sharing all that information. I've learned a lot, and I can hopefully speak for all the viewers as well. They've learned a lot, Nick, as well, in relation to IPO and all those considerations. But we are going to be uploading this to our YouTube as well. And Nick very kindly put the email there that everyone can contact in the chat as well. So certainly do. But without further ado, I just want to thank everyone for attending the webinar and thank you for being very engaging. I'm going to practice my quizzes for next time, though, Nick. I'm going to have to.
No worries. Yeah. Okay. Thanks very much, everyone.
All the best, everyone. Bye-bye.
Thank you.